Hello, this is a presentation by Family First Legal, presented by yours truly, Butrice Walker. Today's presentation will be on Maryland's absolute divorce law. We will be looking at the qualifications for an absolute divorce. There are two main qualifications for an absolute divorce in Maryland, and that is, do you have grounds and do you meet the residency requirements? And on your screen, you should see the overview of what the grounds are and what things are looked at in your residency requirements. Have you been here for the requisite time frame? And do you meet the requisite mindset? And we'll go into these a little more in depth as we go through the slides. Grounds for absolute divorce will either be based on fault or no fault. And just like they sound, fault is when one party is at fault for the absolute divorce, meaning that they are the one who caused the marriage to dissolve. And then no fault grounds are those grounds where no one is considered to be at fault, but divorce is still being sought. And in both situations, you may obtain spousal support or alimony. But in fault, when there's fault found with one spouse, there may be additional things that a spouse may be able to claim, or that they may be able to use that to their advantage to some extent. Not to a huge extent as it might have been in the past, but it still does give some advantage to have the other party be at fault. Now, just because the party is at fault doesn't mean that that party cannot also receive alimony or spousal support. So fault does not block the person from receiving additional supports from the court as well. Now, there are two no-fault grounds for absolute divorce in Maryland. The first no-fault ground is 12 months of separation. And just like it sounds, 12 months of separation means that you have to be separate and apart for 12 months without any cohabitation, meaning there can be no breaks in that time frame. If there is any break where you all come back together and are living together, then that terminates the amount of time you have accrued, and you have to start your 12-month clock all over again. So you want to make sure there's no cohabitation in those 12 months. In addition, there can be no sexual intercourse, and there has to be no hope of reconciliation at the time that you file for your absolute divorce. The second method of getting a no-fault divorce is by mutual consent. Mutual consent requires a written agreement where you and your spouse settle all marital issues. And you'll see here a few of the things listed that you want to make sure to include in any marital agreement or settlement or separation agreement, whatever you call it. You have to include these things particularly, and if there are no children, you do need to identify that in your agreement. And then, in addition, when you go to file for this divorce, it has to be an agreement that has not been set aside by another agreement. So if another agreement's been made to set aside the agreement that you're planning to use to file for your absolute divorce, that agreement won't be able to be used for a mutual consent grounds for absolute divorce. In addition, if there are minor children involved and there's a written agreement, then the court must also agree with the provisions made for minor children. And generally, the court will go along with whatever you and your spouse agree to for the minor children, but the court does have to be satisfied that the child is not losing or being treated in a manner that would be unfair at one home or the other. And therefore, the court will look at your provisions to make sure you've made appropriate provisions for the child or children. Now, getting into the fault grounds, there are several of those, and one that you may know, adultery here. Adultery is a common law standard, meaning that it's something that is not by statute. It's not written into our statutes, but it is something that has been the common law or the common practice to have adultery as a grounds for absolute divorce, where it requires, or has typically under common law required, voluntary sexual intercourse, which involved a female sexual organ being penetrated by a male organ. Now, because of that very graphic depiction, no direct proof is necessary to prove that adultery occurred. Instead, what the court will look for is evidence. And the evidence that it's going to look for is those two prongs you see on your screen there, the disposition of your spouse in the paramour, so it has to be both, and then the opportunity to commit adultery. And when we're talking about disposition of the spouse in paramour, that's do they have a bent or an affinity towards engaging in extramarital affairs? Has your spouse had a previous affair, or has your spouse engaged with this paramour in the past? Whether it's prior to or after marriage. Does this paramour have a history of being with someone who is married, or in particular being with your spouse? These are things that might show disposition, and you can do this by witness testimony or by other evidence that shows that they have some sort of disposition towards engaging in adulterous affairs. Then they must have the opportunities. And the opportunity must be a time where they're alone, or they have the opportunity to engage in sexual intercourse. And the opportunity can't be something that can be explained away by an innocent manner, such as we work together and this is what's required of our job. Or if the situation arises where they're alone, but it's not a continuous or ongoing thing, it wouldn't necessarily create the opportunity. But when you have something where you have the parties meeting or engaging in activities outside of a normal routine or outside of what would be expected of them, and they're doing so in a private manner or in a way that holds them out as having a relationship, and they're doing this continuously, that might show opportunity to commit adultery. And so you want to look to the standard. When you're thinking about these two prongs, think about the standard here. And the standard is that you have to have evidence that proves these two prongs by a preponderance of the evidence, meaning the majority of the evidence has to lead the court to believe that the behavior engaged in by the parties couldn't be better explained by the possibility of innocence. So if you're saying they have the disposition or the opportunity, then whatever evidence you're using can't be just simply explained away with a plausible, innocent scenario. So just think of that as you're thinking through your scenario if adultery is the grounds you're considering using here. And then suspicion and indiscretion are not enough to get adultery. So if you're just suspicious, maybe they've done something, and you may be right in your suspicion, but without the proof or the evidence that provides that there's no other possibility of innocence, and that disposition is there and that opportunity is there, you're not going to be able to get adultery based on that suspicion without those things. So do recall that. And if you can't get that, later on I'll be talking about desertion. And desertion is a way that you might actually be able to get a divorce for someone who's engaged in an adulterous affair, but you don't have the proof to prove that yet. So you may want to use the ground of desertion, which is coming up next. So desertion was previously called abandonment, or may have been referred to as abandonment. It requires a duration of 12 months, meaning that this must have been continuous for 12 months. And desertion must be unjustified, deliberate, and the person who's leaving or who has deserted must have had an intent to desert, which lasted the entire 12 months or greater. And that there's no expectation of reconciliation. Now, desertion can be actual or constructive. And what that means is that if it's actual is where your spouse actually leaves. They actually desert you and leave for a 12-month period of time with the intent to leave you behind and with no intent on reconciling with you or anything like that. Now, constructive, as I mentioned earlier, there under a desertion, you may be able to use something that or evidence that doesn't rise to the level of adultery under constructive desertion. And I'll show you that here in just a moment. Constructive desertion is where one spouse forces another spouse to leave either by force or by their conduct. So the conduct that can be used here to determine whether you've been forced out by your spouse is, has that spouse engaged in cruelty, unjustifiably refused to have sex or sexual relationship with you, unjustifiable refusal to live separate and apart from their parents. They continue to want to live with their parents even though you can afford to do better, and there's no other reason for you to live with their parents of that spouse. That spouse has abnormal sexual demands that they're asking you to engage in, and that's continuous. And then the spouse has behavior with another person that could be a paramour, but it's short of adultery. You don't have enough evidence to prove adultery. In that case, your suspicion would be enough to file for absolute divorce under the grounds of constructive desertion. And then the last one I have here is the unjustified complaints of fidelity, where your spouse continuously complains that you're being unfaithful, even though you are being faithful in the relationship. And that would be conduct that forces you to leave the home. Okay, and moving on to the next ground for absolute divorce, we're talking about cruelty, excessively vicious conduct. So those are actually two separate grounds, but they're very similar. So I've combined them together here. It's going to cruelty or excessively vicious conduct can be against the spouse or the child or children in the case. And then it usually must be continuous. If it's cruelty, to show that it's cruelty, it has to be continuous. However, an excessively vicious act that is severe may rise to the level where one act is enough to be able to use this as grounds for absolute divorce. And then in addition to it being a vicious act or continuous, there has to be no reasonable expectation of reconciliation in the situation for this to be a grounds for your divorce, your absolute divorce, that is. Grounds for absolute divorce that may be more difficult to obtain are the criminal incarceration and the insanity grounds. And the reason why I say more difficult is because under the criminal incarceration grounds that you would have here, your spouse must have been found guilty of a felony or misdemeanor that's punishable by at least 3 years or more. And they must have served, or they must be sentenced to serve at least 3 of those years. And before you can file, they must have served at least 1 of those years already. So they must have the lowest sentence they would be able to serve would be 3 years, and then they've already served 1 year, and now you can file for an absolute divorce. So that's a lot of time management there. And, if your spouse is convicted of a crime and only sentenced to 1.5 years, that's not grounds for a divorce, for an absolute divorce. And insanity is extremely difficult to get. And I definitely have talked with people or individuals, potential clients about this area where they're thinking, oh, my spouse has a mental health issue and that issue is just pervasive and there's nothing we can do to work things out. But it will not fall under these grounds of insanity usually, because this prong requires that confinement to an institution or a hospital has occurred for no less than 3 years prior to filing. And at least one of you must have lived in the state of Maryland for at least 2 years prior to filing. And then in addition, to make it even harder, there must be 2 or more physicians competent in psychiatry who can certify that your spouse is insane and incurably so, meaning that there's a very low or no likelihood that your spouse can be cured from the insanity. So a very high threshold there. Now, there are some defenses for absolute divorce. To adultery, there are some defenses listed here, but a couple of these aren't going to completely bar you from using the grounds of absolute divorce. And connivance is probably about the only one that will almost every time be a complete bar to any kind of absolute divorce based on adultery. And connivance is basically where you consent to your spouse engaging in an adulterous affair. And at that point, the court does not want to give you the right to file on the grounds of adultery because you consented to it. You agreed to allow that to happen. And then condemnation and recrimination, while these are factors that the court will consider when granting grounds of adultery, they're not conclusive, meaning having those things alone do not necessarily bar an adultery claim. So condemnation is forgiveness, where you forgive your spouse for engaging in an adulterous affair, and that can be assumed or presumed by the fact that you took your spouse back, you're living in the same household, you're seen together, you're engaging in marital behavior. That can be seen as forgiveness or condemnation. Now, that can be taken as a factor in a defense against adultery, but it is not conclusively a defense against adultery. Recrimination, similarly, is where both spouses have both engaged in the behavior, and recrimination cannot automatically bar adultery as as a defense to adultery, but it is a factor the court will take into consideration as it's determining whether the grounds of adultery can be used for absolute divorce. In desertion, if you're using constructive or actual desertion, if you consent to the desertion, then that may be a complete defense against using those grounds. So your spouse may have a defense if you're saying your spouse deserted you, but in fact you've agreed with your spouse that you will separate. Then that's consent, and consent will bar you from being able to use the grounds of desertion for your absolute divorce. Cruelty. When you're trying to allege grounds of cruelty for your absolute divorce, then you have to be sure that you're not the provocateur. In this case, where you provocate the cruel act of your spouse by engaging in your own cruel act, the court is unlikely to grant you an absolute divorce based on the grounds of cruelty. And then there are some general defenses. Anytime you have a time frame that's required under any of the grounds, then your case is not ripe for filing for an absolute divorce, meaning you haven't met the time frame. That will bar you from being able to use that ground for absolute divorce. Now, moving into the residency requirements, they're pretty simple here, but generally one party must reside in the state of Maryland for at least 6 months prior to filing for an absolute divorce. And the requisite intent here is that the party must have an intent to remain in Maryland. So not only do I live in Maryland for 6 months, I have an intent to remain in Maryland. The court usually doesn't look very closely at that unless it's questioned by one of the parties. And then there is something you should note, that if you are able to meet all of those standards that were required for insanity, to use insanity as grounds for divorce, you do need to remember that that is a 2-year residency requirement. So one party will have to have been a resident of Maryland for at least 2 years before you can use the grounds of insanity for absolute divorce. Now we're going to discuss the other considerations for an absolute divorce. So other things that you want to think about when you're considering an absolute divorce. In an absolute divorce, you will be able to change your name back to a premarital name if you changed your name when you were married. And that's usually when a spouse changes their last name, and sometimes they will even change their middle name. So whatever your name was premarital, you are able to change it back in an absolute divorce proceeding. If for some reason you forget to request that name change during your divorce proceeding, you have 18 months to come back and request from the court to add to your decree a request for that name change and to get your name change back to your maiden or to your principal name prior to marriage. Now, if you are past that 18-month mark, then you will have to file for an adult name change, just like anyone else who's trying to change their entire name or even portions of their name. You would have to pay additional filing fees to do this, and then there would be a posting requirement to get your name changed in that situation. Property and alimony. So property will be divided into categories when you're going into a divorce, an absolute divorce, and then the court will look at who the property belongs to based on the category it falls into. So marital property will be property that needs to be divided between the marital couple, and then separate property will be property that's deemed to belong to one spouse or to the other spouse. Mixed property is that property that's probably the most disputed and most debated, when one party wants to claim that it's separate property, that they own it alone, and the other party wants to claim that property as marital property. Then it becomes mixed property, possibly if part of it was actually separate and part of it was marital. And then the court will have to get involved to kind of decide which portion of it is marital and which portion of it is separate property. And then the court will divide the marital property, the portion of this marital property, between the spouses. And then there's such a thing as tracing, and that's usually used when you're trying to split mixed property. So for instance, if you purchased a home and you had almost paid that home off prior to getting married, you paid on it for 1 year during your marriage, you paid on a 30-year mortgage, and 29 of those years you were on your own paying for it, and then you got married and you made it the marital home. Now, this is not necessarily true, but what could happen in that situation is that 29 years of that home's equity is considered as separate property. But because you were married for 1 year while you were continuing to pay on that home, the court may deem that as marital property for that 1 year. So the separate portion of that home is traced back to the initial purchase that you made prior to marriage. So it wasn't originally marital property, so that tracing would trace back to show us that. So that means that part of that could be considered separate. But then the court would have to figure out how to divide the portion that would be marital property and how to allot that. And usually that has something to do with fair market value and determining how to evaluate the home or the property, whatever type of property it is. And the court must have jurisdiction over the property in which it's making decisions over. If the court doesn't have jurisdiction over the property is out of state and not able to be brought under the jurisdiction of the court, then the court cannot make a disposition on that piece of property. It may require additional legal behavior to get that done. Alimony is generally going to be based on the circumstances, and I've listed a few circumstances here that you can consider as you're thinking about whether alimony is worth you going after as a spouse, or whether your spouse is entitled to alimony. So just think about these things. These are just some of the factors that you would consider. There may be more, but surely these aren't conclusive, so it doesn't mean that if you meet 2 or 3 of these that you're conclusively going to be awarded alimony, or that you'll get it for an extended period of time, even if you're granted alimony. It just means that you may be eligible for alimony. Now, there are different types of alimony depending on what your needs are. So an example of one type of alimony is rehabilitative alimony, which is usually for the spouse who hasn't worked during the marriage, or who has worked but has a lower education level and will need to obtain more education in order to be better employable, or in order to make more money to support the lifestyle that was there during the marriage. So the court would allow that spouse to receive alimony for an amount of time the court deemed reasonable to allow that spouse to receive education or training necessary to enhance or increase their earning ability. And personal jurisdiction is necessary over the spouse who is going to be paying alimony if the court is going to be awarding alimony. Alimony will be assumed to be, or presumed to be, modifiable or canceled upon remarriage unless you have stated otherwise in an agreement. And that's if you did like a settlement agreement or a marital separation agreement. In that agreement, if you don't specify that the alimony is not modifiable, then it is modifiable by law here. In alimony may not be sought after all property is disposed of in a final divorce decree. So after your final divorce decree is granted, you may not go back and then say, oh, I forgot to ask for alimony. You need to ask for alimony up front in your divorce proceedings. And now getting to one of the last segments of our session here, parenting plan and child support. So this is only going to be important to you if you have children or a child involved. You will need to develop a parenting plan. If you and your spouse share children, you will need to address physical and legal custody. The physical custody being where the child will live primarily, and then where the child will visit, and the converse. And then legal custody, who will make the big decisions for the child. And something to consider is whether you need tie-breaking authority. Tie-breaking authority can be limited, or it can be global, meaning it covers all things, giving one spouse the ability to make decisions over some things or all things, if in the event that the two cannot agree on something that pertains to a child. And then thinking about your holiday and school schedules, how they might impact your parenting time and your parenting plan, and even your work schedule. If you are some professional who works numerous hours, there's no need to go in and fight to get physical primary custody of your child if you know you're not going to be able to keep your child during that time, and then end up accruing childcare expenses that are unnecessary. I mean, it's a balancing act, so you really have to determine if that's worth it for you. And some people will do that because they don't want to pay the child support and try to get more custody. Here, moving into the child support arena, both parties are responsible for supporting the child, so the calculations used by the court will be based on the incomes of both parents. And it will also the amount or who pays will be based on who has physical custody and then who has the visitation days. So how many days you have the child will decide whether child support or whether you should be eligible for child support. And in that case, the court will use a calculation to determine how much child support should be allotted based on the incomes of both parties and the needs of the child or children. And that is pretty much an overview of the absolute divorce process in Maryland. If you have additional questions, please feel free to reach out to us. Again, use our contact us page at www.fflmd.com and let us know what you're thinking and what other questions you would like for us to answer for you. Thank you.